A federal bankruptcy judge recently heard arguments in the case of Shilo Sanders, a Colorado football player, regarding his attempt to discharge over $11 million in debt through bankruptcy proceedings. Judge Michael Romero did not make a ruling immediately, instead raising questions about whether there was sufficient evidence to prevent Sanders from clearing this debt. The case could ultimately go to trial to assess Sanders' mental state during an incident in 2015, when he allegedly assaulted a security guard, John Darjean, at his former school. In 2015, Darjean, a security guard at Sanders' school in Dallas, tried to confiscate Sanders' phone. Darjean claims that Sanders struck him with a roundhouse elbow, which caused permanent injuries, including spinal issues and incontinence. Darjean sued Sanders, and in 2022, he won a default judgment of $11.89 million after Sanders failed to attend the trial. Darjean's attorneys argue that this debt should not be discharged because it resulted from a willful and malicious injury by Sanders. Shilo Sanders and his attorney, Victor Vital, contend that the debt should be dischargeable, as there is no clear evidence that Sanders' actions were willful or malicious. They argue that the judgment from the Texas court does not explicitly state that Sanders' actions were willful and malicious, which is a crucial element required by law to prevent discharge in bankruptcy. The judge is now tasked with deciding whether this technicality will determine the case's outcome. Shilo's bankruptcy attorney, Kerry Riley, confirmed that Sanders has already turned over significant financial information, including his tax returns, bank statements, and documents related to endorsement deals. Sanders has also provided about $210,000 to the bankruptcy estate and had his apartment inspected as part of the bankruptcy proceedings. However, Sanders did not attend the hearing, as he is preparing for his football game with Colorado against Texas Tech on Saturday. In bankruptcy, debtors can typically discharge their debts to get a fresh start. However, debts resulting from certain types of misconduct, like willful and malicious injuries, are exceptions. Darjean's attorneys argue that Sanders' actions in 2015 fall under these exceptions, and they contend that the judgment in Texas court should be sufficient to establish that the injury was indeed willful and malicious. Judge Romero also questioned the necessity of relitigating the entire assault case. He emphasized that the central issue in the bankruptcy case was Shilo Sanders' mental state at the time of the assault. If the judge ruled that Sanders' actions were indeed willful and malicious, then the debt would not be discharged, and Shilo would remain liable for paying Darjean. On the other hand, if Judge Romero denies the summary judgment request, the case would move to trial, where the critical issue would be whether Sanders' actions were willful and malicious. This trial would delve into Sanders' mental state at the time of the incident, which could be a complex and contentious process. If the judge rules against Sanders, it would significantly impact his bankruptcy case. He would remain responsible for paying the debt to Darjean, and his attempt to start fresh financially would fail. Darjean's attorneys desire to move quickly and efficiently, seeking access to Sanders' financial records and assets to ensure Darjean can collect the judgment. They have requested subpoenas to investigate Sanders' finances, including information from his father, Deion Sanders, and third parties, and documents related to Sanders' name, image, and likeness, nil deals. The outcome of this bankruptcy case is still uncertain, but if the case proceeds to trial, it will center on whether Shilo Sanders acted with the necessary intent to prevent his debt from being discharged. The judge's decision could hinge on nuances in legal definitions and evidence related to Sanders' mental state at the time of the alleged assault. Regardless of the outcome, the case highlights the complexity of bankruptcy law and its application to individuals seeking to discharge large debts resulting from severe legal disputes.